Welcome, dear colleagues, to the first event of the ABILA International Law Weekend, which is now extended to an international law season by the existence of this event and others. I'm Mortimer Sellers, Regents Professor of the University System of Maryland, but more important for our purposes today, I'm Chair of the International Law Association Study Group on the Rule of Law in International Relations. Also present at this webinar are Professor Miroslava Antonovich of Kiev-Mohyla Academy in Ukraine. She is the rapporteur of the ILA study group on the Rule of Law in International Relations. And our webinar today is sponsored by the American branch of the International Law Association, and specifically the ABILA Committee on the Legitimacy and Fundamental Principles of International Law, chaired by Professor Ioana Turco-Coriti, who is also present at this webinar but cannot speak today as had been originally planned. It's particularly important that we discuss the rule of law right now and with close attention, because the rule of law is particularly under threat in international relations. Powerful nations, including members of the Security Council, are deliberately challenging the authority of international law and of international institutions, which threatens our shared commitment, the ILA commitment, to peace and justice through law. So we are indeed very fortunate to have as our discussants today Professor Gregory Schaefer of the Georgetown University Law Center and Professor Margaret deGuzman of Temple University Beasley School of Law. Professor Schaefer is the Scott K. Ginsburg Professor of International Law at Georgetown and former president of the American Society of International Law. He's a leading expert on international economic law, but also on the global rule of law, on which he has just published a book with Cambridge University Press. Professor deGuzman is the I. Herman Stern Professor of Law and co-director of the International Institute for Law and Public Policy at Temple University. She serves as a judge on the International Residual Mechanism for Criminal Tribunals and is an expert on international criminal law. Her books include Shocking the Conscience of Humanity, Gravity and the Legitimacy of International Criminal Law, published by Oxford University Press. This webinar will take the form of a roundtable. Professor Schaefer will speak briefly, about 8 minutes. Then I'll speak briefly, then Professor deGuzman. We shall then each very briefly respond to each other, and then we shall engage with you, our audience, taking your questions and comments, which will be posed to us by Freya Doughty Wagner, who is the Chief Operating Officer of the American branch of the International Law Association. So, Professor Schaefer, you have the floor, 8 minutes or so.
Oh, okay, great. Well, thank you, Tim. Thank you, everybody. I'm going to start, I think, just sort of the way I view the rule of law, and I'm going to build this from my book on the rule of law under pressure, a transnational challenge. And it's really a transnational challenge because we're seeing the, pressures on the rule of law around the world. And actually empirically, we're seeing declines, not only in the United States, but in many countries across all the world's regions. And in the book, and what I want to do a little bit today is talk about the links between international law and the rule of law domestically. And so, first of all, though, that raises the question, what do we even mean by the rule of law? And different actors put forth different conceptions of the rule of law. The Bretton Woods institutions, the World Bank for a long term sort of focused on contract and property rights. The Kofi Annan, when he was Secretary General of the United Nations, focused more on human rights. The UN Security Council, when it creates rule of law initiatives, tends to focus more on peace and security and thus law and order. And so these are very different conceptions. Of course, we had many philosophers who have written on the rule of law in more abstract terms, but they disagree as well. And for that reason, the philosopher Jeremy Waldron calls the rule of law an essentially contested concept. I think that that's generally is an accepted view on the one hand, and on the other hand, I think it's mistaken. And I think it can lead to perverse outcomes. Once the concept of the rule of law becomes an essentially contested concept, then it risks becoming one more tool in an arsenal of lawfare that opponents use against each other. Both Presidents Biden and Trump reference the rule of law while attacking their political adversaries. President and Chairman Xi Jinping pronounces a vision of the rule of law with Chinese characteristics where the Communist Party plays a preeminent role. So I have a different starting point, and I do so in line with a sociologist and social theorist, Martin Krieger, and his work. And it's more universalist in terms of the goal of the rule of law, but certainly anything but universalist in terms of the mechanisms and means to address it. So the goal of the rule of law has a point, and that is it's to temper the arbitrary, unbridled exercise of power. The goal of the rule of law is to oppose the arbitrary exercise of power by setting boundaries on and channeling power's exercise through known legal rules and institutions that apply to everyone. And what matters is the institutionalization of these norms, these constraints, so that it count as a source of restraint and as a normative resource for all of us, so that they become ultimately, ideally, a culture of practice. Now, note, I do not define the rule of law in terms of legal compliance, because law itself can be problematic, whether it be national law or international law. Take the law of Nazi Germany, or of apartheid South Africa, or of the Jim Crow South, or in other words, the apartheid America, or the Berlin Conference of 1885, which carved up the territories of Africa for colonial rule. It's thus critical to distinguish the rule of law as an ideal, as an aim, a practice to constrain temper the arbitrary exercise of power, from the idea of rule by law, where law, of course, can be used to oppress and to suppress. Now, given that there's many different cultures and historical traditions around the world, there's no one means to advance the rule of law, support it. It's not just a European sort of means or American means. And the challenge is that often people go on the road and try to transport their institutions, their means, to countries where they simply don't fit with the cultural practices and traditions of those countries. Now, there are different definitions of arbitrariness, and I just want to address sort of the way I think about the arbitrary exercise of power. One can look at Black law, Black's dictionary on arbitrariness and so forth. But what I think what's more important is really from a problem-centered approach. What are the problems that we wish to address? I think the primary, and in the book, I point out five sort of primary sources of the arbitrary exercise of power that we want to check. And I'll first talk about these sort of generally, and then maybe in the Q&A, we can move to international law itself. But a first primordial concern is where the wielder of power is not subject in practice to the law, its controls and limits. We can think of that domestically in terms of the president. When the U.S. Supreme Court in Trump v. United States said the president is granted absolute or presumptive immunity regarding official acts, that, of course, empowers the president to violate the rule of law in practice. And when you combine this with the pardon power of the U.S. president, you see the danger that faces us today. It's concerning not only in the United States, but also because what develops in the United States, given their U.S. power, can be used as an example and normative resource transnationally by others in power. A second source of arbitrariness is where we just can't know or predict how power will be wielded over them. And thus Lon Fuller and others talked about, the importance of transparency, of the rules should be known, they should be non-discriminatory in their application, they should be prospective, coherent, consistently applied. Particularly concerning is the risk of arbitrariness in the form of discriminatory threats in prosecutions. It recalls the authoritarian trope, for my friends, everything, for my enemies, the law. It's central to the hypocrisy of the arbitrary exercise of power and the use and the wielding of law. A third source of arbitrariness is where there's no institutional machinery to protect the rule of law, and it's controlled by those in power so that individuals have no place to be heard, informed, question, or respond to how power is exercised over them. This aspect is captured by many legal theorists of just the importance of having a neutral, impartial institutional machinery to protect us against arbitrary exercises of power. A fourth source of arbitrariness is where authorities do not engage in reason giving in issuing their decisions, which reasons can be contested. We don't all agree, but if we actually commit to using reasons and the ability to contest those reasons, we're at a much better space. So think about today, and also go back to the Nazi theorist Carl Schmitt. Carl Schmitt defined sovereignty as he who decrees the exception. Well, national security is the mother of all exceptions. When any and everything becomes a matter of an exception of national security, and there is no judicial review or exceedingly deferential judicial review, then there's no longer any check on powers exercise. And then let me just talk finally about a fifth source of arbitrariness, which is proportionality of any measure in terms of the reasonable relationship of means to ends. Think of Navalny in Russia, prosecuted for, relatively minor crimes, but then put in prison in Siberia, basically until he died. Autocrats use such disproportionate sanctions around the world to stifle opposition. Now, those are the 5 sources of arbitrariness I think we can address, and we can apply them to international law. But I just want to stress that we need to not to go beyond sort of these formalities of legality and really focus on what's the goal, the point of creating the rule of law. And that is to be able to check the arbitrary and constrain, to temper the arbitrary exercise of power so that we live without fear, so that we live without intimidation, without coercion, and the threat of the arbitrary exercise of violence on us. So thanks.
Thank you. Thank you very much, Professor Schaefer. I shall speak next. Followed by Professor deGuzman.
Thanks.
The mission of the International Law Association, the mission of our association, is to seek peace and justice through law. And this reflects the belief and the reality that peace and justice are only possible through law, and more specifically through the rule of law. Without law, there cannot be peace or justice, which is not to say that the mere presence of law is enough to secure these extremely valuable goals, but the rule of law is an indispensable condition. The Universal Declaration of Human Rights, approved by the General Assembly of the United Nations without dissent, recognized, and I'm quoting now, that it is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. And more recently, the General Assembly in 2006 identified human rights, the rule of law, and democracy as universal and indivisible core principles of the United Nations. These ringing assertions are repeated or paraphrased in the European Convention of Human Rights, the American Convention of Human Rights, the African Charter of Human and People's Rights, and numerous other regional agreements and national constitutions. But what is this rule of law to which we are so committed? The rule of law at its heart is the negation, and in this I agree with Professor Schaefer, the negation of arbitrary power. The fundamental principle of the rule of law, since the phrase was first coined in Roman times, the imperium legum in Latin, the rule of law signifies that the law should rule and not men. The rule of law and not of men has been sought ever since. No person, no nation, no institution, no faction should have arbitrary power. It should always be ruled and controlled by law. Controlled to serve the rightful purposes of law, which are justice and peace, or peace and security, as it says in the United Nations Charter. Peace and security, and here again I'm quoting, in conformity with the principles of justice and international law. So the rule of law in its best and most usual and traditional sense signifies the fulfillment of justice through law and the negation of arbitrary government. Most of the history of the concept of the rule of law, from the Rome of Livy and Tacitus to the preamble of the Universal Declaration, most discussion of the rule of law has focused on the rule of law within states, subjecting kings and despots to the rule of law, preventing them from exercising arbitrary power. Magna Carta, habeas corpus, the whole history of constitutionalism is the story of the pursuit of the rule of law. The attempt to secure the rule of law by securing judicious checks and balances to control the powers of the officers of the state. We often attempt the same in international relations. We try to create a balance of power that will guide us towards justice and peace. Such was the purpose of the many peace congresses over the past 3 centuries, later the Covenant of the League of Nations and the United Nations Charter. So the concept of the rule of law has 2 parts. First, the principle that all arbitrary power must be restricted by law to serve the common good. In this case, in our case, the good of the global community. And second, the institutions and orders of government that are possible. First, the principle of the rule of law. So the principles are the first concern, I think, here. But second, the institutions. So there are 2 parts to this. Both have to be studied. Both have to be developed. International law differs from many national or domestic legal systems in that, although for the most part the fundamental principles are well known and widely understood, the fundamental laws, as it were, are widely known and well understood, I think, across the globe. The institutions that interpret, adjudicate, apply, and enforce these principles, the institutions are highly underdeveloped and for the most part poorly constructed and weak. So for a group like the International Law Association, a group that wants to promote the rule of law in international relations, a group whose members are very learned in international law, perhaps uniquely so, but for the most part outside government, what is our task? And again, I think it has 2 parts. First, to articulate as clearly as possible the fundamental principles of international law, the foundational principles, the central principles that should govern and control the actions of states and their governments, the central norms of international law, of the international rule of law. And second, to study how they might be made to have greater influence in fact, not only on the relationship between states, but also within states. And the global reach of the International Law Association will make this possible. Our strengths are in our learning, in other words, the ability to state the most fundamental requirements of international law well and clearly, but also our presence and participation everywhere in the world to make the international rule of law as much as possible a reality. We have, I think, more than 200 people present on this webinar right now. 200 people from every corner of the globe who have been made aware of this through the International Law Association. And so this is an opportunity, I think, for us to consider how we can strive together to make the rule of law more certain in reality. Thank you very much. Our next speaker will be Professor Margaret deGuzman.
Thank you so much, Tim and the organizers of the webinar for organizing this important event and including me. I have to say to start that I am speaking in my scholarly capacity today, not as a judge of the International Residual Mechanism for Criminal Tribunals. I also want to thank two fabulous research assistants, Megan Gold and Emily Valdez, with whom I've been thinking about the issues that I want to raise today about the rule of law. And I want to say that what I have to say today, I'm saying to them and to the younger generations that are going to be grappling with these questions. And I think are going to face some very hard choices in the near term. We are living in an era where even basic norms of human decency are under attack. And so it's hard to imagine what I'm going to invite us to imagine today, which is a world transformed by love and care. And I'll explain why that is important to any concept of the rule of law. So that's my goal in my 8 minutes. I want to start by acknowledging what Professor Schaefer said at the beginning about different understandings of the rule of law. And I'll quote Brian Tamanoha in this respect, who says, "The rule of law is an exceedingly elusive notion, giving rise to rampant divergence of understandings and analogous to the notion of the good in the sense that everyone is for it, but have contrasting convictions about what it is." Now, while I agree with both Tim and Greg about the importance of thinking clearly and doing our best to define rule of law, I'm going to speak in a bit of a different register to you about the rule of law. And I'm going to suggest that while it is important to think about law as a constraint on power, it's important to understand that the distinction between law and power in practice is an artificial one. And it's one that we have to interrogate in order to understand how to put any conception of rule of law into practice. So I'm going to start with feminist scholars' critiques of traditional approaches to rule of law. And feminists have taken issue with rule of law's centering of autonomy and its treatment of individual rights, and talked about the importance of emphasizing the entrenching of the invisibility of the private sphere. And there are many foremothers that I want to give credit here to, and Fionnuala Ní Allain is one in particular that I'll shout out to here. It's important to understand that maximizing freedom means limiting the state's ability to intervene in not just public matters, but also private matters. So feminists have questioned this division between public and private, and questioned this idea that law is just about the state's ability to intervene, maximizing its ability to intervene in certain kinds of matters, but not others, especially when issues that are typically classified as private tend to most affect women. Issues related to domestic labor and the private suffering of women are often considered outside the rule of law, in other words. And we have to interrogate that division in order to really understand what it is that we want when we say that we want the rule of law. Additionally, typical traditional discussions of the rule of law focus on individual rights. And this also is an inadequate framing from a feminist perspective. The rule of law's emphasis on individual rights frames individuals as abstract bearers of rights, rather than looking at our common humanity in a more holistic way and our interrelatedness more holistically. And so this simplifies a complex reality about power relations that is implicated by law. I also want to invoke here 12 critiques of the rule of law, and I'll in particular quote Tony Angie when he points out that the rule of law has been used to justify, for instance, colonialism. And he says the colonial state sought to establish order and stability, a rule of law that was compatible with the extraction and exploitation of the resources of the colony, and that could deal with local violence by recourse to emergency rule. The rule of law rhetoric continues to be marshaled in service of Western interventionism in other contexts as well, including in development agendas, etc. So recognizing this relationship between the rule of law and imperialism, it's important to remember that we can't put imperialism or its current instantiations behind us when we think about what kind of rule of law we want to see in the world. So given these critiques, what is it that I want to suggest we ought to be striving for in terms of the rule of law? And this is where I want to suggest something that I suspect will be heard as somewhat radical and perhaps with some skepticism, but I hope that it'll maybe give rise to some interesting discussion. And that is that we should consider the role of emotion in the formulation and application of law. We've seen a lot of law recently that seems to be motivated by hate. And we've even seen some very direct invocations of hateful rhetoric in talking about what the law ought to be and how it ought to be applied. And I want to suggest that instead what we should be working toward is a centering of love and care in the creation of law, the application of law, and in how we think about the rule of law. We shouldn't just emphasize human reasoning and calculation without any engagement in the emotions that motivate and drive particular ways of reasoning and calculating. Robin West, another of the foremothers that I want to invoke here, has talked about the centrality of human morality for the caring for others. Our capacity for care should be at the center of our understanding of our public and legal virtues, and it should be central to the meaning of legal justice. She says, I've omitted a few words there, but that's just the essence of a quote from Robin West. So the feminist ethic of care is what I'm invoking here to suggest that we should strive for more than the protection of rights against certain kinds of state overreach and have a more ambitious understanding of morality in our legal system. And we also, in this vein, have to interrogate the understandings of peace and justice that we use when we talk about the goals of the rule of law. I think it's important to think about individual rights and fairness and equality, but not in abstraction and not in a way that is divorced from centering care for humanity and for all of us in community. Attentiveness, trust, responsiveness to need, and cultivating caring relations should also be at the center of what we talk about when we talk about the rule of law. So justice itself should be understood as encompassing the ethic of care. Love, therefore, should be central to our conversations about the rule of law. And I want to cite Bell Hook here when she says that young listeners are often reluctant to embrace the idea of love as transformative. And for them, it is naive, weak, and hopelessly romantic. And I don't think it's just young listeners. I think there are many skeptics of the centering of love in these conversations, which is why I said at the beginning, I'm hoping to be a little bit radical here. And I want to invite us to interrogate that skepticism and to see if we can overcome it, honestly, in service of providing a counter to the ethic of hate that I think is motivating a lot of discourse at the moment. I think, Tim, how am I doing on time? I think I have just a couple more minutes. If I do, I'll say like one or two more things. Is that okay?
You have come to the end, and you absolutely can say one or two more things.
Okay, sorry, I didn't quite keep my time there. Just a couple more things. I think that I want to end on a note of optimism, because even though, as I've said, we do see a lot of very challenging rhetoric and actions in international law and relations today, I think there are also some rays of hope. And so I wanted to end on a note of invoking that hope. I think the International Court of Justice climate decision is one of those rays of hope. The court talks there about states' responsibilities toward current and future generations. And they don't use the word love in this context, but I think that that is really what is underlying this decision. The idea of intergenerational equity as the invocation of the obligation of present generations as trustees of humanity, tasked with preserving dignified living conditions and transmitting them to future generations. And there I'm quoting from the decision. I think really has at its center the concept of caring for one another as we implement the rule of law. Another ray of hope, I think, can be found in the court's invocation in some recent decisions of obligations erga omnes partes. There are some recent decisions where this has been really central to the court's reasoning. Again, I think those can be understood in relation to notions of love and care. And then I'll just add a very specific note of something that I'm researching more actively at the moment in this regard, which is the Colombian peace process and the way in which that peace process pushed back against norms of prosecution and punishment and centered restorative justice and the needs of victims and communities. So thank you, Tim, for allowing me to go a minute over. I look forward to the discussion.
Thank you very much, Professor deGuzman. And now we're each going to just briefly react slightly to what each other have said as a way of introducing the broader set of questions from those who are here on the webinar. Professor Schaefer, you go first.
Great. Well, thanks, Tim. And so since there was more in parallel between what you and I said, I could elaborate. But I wanted to engage with Meg a bit because she said some very important things, and some of which, most of which I'll agree with and want to emphasize, but the other I want to warn against. And that is when we talk about the rule of law and its relationship to power, I think it's very important to recognize that the rule of law is not an anti-power. One needs power to do things. One needs power to accomplish exactly the things that Meg was talking about. And so what the rule of law is, it's a constraint on the arbitrary exercise of power, not on power itself. You need power to actually support the rule of law. And I think that then this is sort of highlighted by a feminist theory, but also by many other theories. When we think about the arbitrary exercise of power, it's not just by the state, not just by governments, it's also by private entities. And so you need state power to constrain the arbitrary exercise of power by private entities. And once we start thinking about that, of course, it becomes more complicated in terms of international law, such as in my realm of international economic law, because many corporations are actually much wealthier and more powerful than many states. And so you need state power to regulate corporations, for example, to regulate the arbitrary exercise of power. So I think that's this very critical to, focus on the relationship of the rule of law and power. The second is, I think, and this is a response to Meg noting Tony Angi's sort of critique of colonialism in the rule of law. Anybody can use rule of law rhetoric, but that's not the way we should think, or in my view, the symposium, this sort of initiative should think about the rule of law. The rule of law, I think Tony's work, highlights the arbitrary exercise of power by colonial powers over those who are colonized. Slavery clearly is an arbitrary exercise of power here by private entities, not just the state. And so it's very important to think about how law can be used to oppress, to suppress, and how the rule of law rhetoric can be used to oppress and suppress. But for that reason, it's essential we distinguish the rule of law from the rule by law. And it's dangerous. And let me just give a famous quote in terms of international law by the book by Ernst Fraenkel, The Dual State. Ernst Fraenkel, of course, is writing about law in Nazi Germany. But what he really pointed out was that what the Nazis did first was to attack international law and international institutions, because they did not like the scrutiny and the surveillance that the League of Nations was giving and receiving petitions from Jews with respect to Nazi persecution of Jews. And he wrote, and this really stunned me because it's a book about national law. He wrote that the legal theory of post-war German counter-revolutionists was decisively influenced by international events, and the concept which permitted an unlimited sovereignty to ignore international law, which became the source of the theory that political activity is not subject to legal regulation. That was the source of the Nazi theory of the prerogative state, that the state could act at its whim and will. It was its prerogative, and there was no check on it. And so international law and national law are interrelated. And then I just wanted to really stress the importance of what Meg said about the relationship between love, joy, and the emotions to the rule of law. Love, joy, community, care, they're all a form of resistance. And of course, Blacks have known this for a long period of time in the United States with respect to Negro spirituals, the music, and so forth, to try to find a space for joy, love, and care of each other. And the point of the emotions actually is central to, say, the work of Spinoza, right? In response to the war of religions and all the hate between Catholic and Protestants, killing each other over their visions of the good. And in contemporary work, especially since it was mentioned Columbia, let me just note that Columbia's a writer and theorist, created De Justicia in Bogota, in Colombia. And his name is Mauricio Garcia Villegas. And Mauricio Garcia Villegas is really focused on the challenge with respect to the rule of law in Latin America because of what he calls the negative emotions. And that in Spanish, the title of the books are Las Emociones Tristes. And that's hate, envy, greed, and so forth. So emotions, of course, are positive emotions, the ones stressed by Meg, and negative ones. And it's much of these negative ones which have given rise to the arbitrary exercise of power against those with whom one disagrees, those who one hates, those who one wants to suppress. And it's to cultivate sort of the norms of care, community, and so forth. It has a reciprocal relationship to the rule of law in terms of the arbitrary exercise of power. If we cultivate those positive emotions, we're more likely to have rule of law type governance. If we if we have societies which are unhealthy, which are torn apart by hate and greed and selfishness, then we're more likely to see the arbitrary exercise of power. So they go together.
Thank you very much, Professor Schaefer. Like Professor Schaefer, I admire Jeremy Waldron, but also like Professor Schaefer, I think he is mistaken and in fact does real damage by describing the rule of law as an essentially contested concept. It's not. There are two rival conceptions of the rule of law, both simple, both easy to understand, both well understood since the time of the Romans. Rule of law, and again, I suppose I'm agreeing more than I should with Professor Schaefer, but rule of law and rule by law, they're distinct. The first, sometimes called by philosophers the thick conception of the rule of law, is what I'm advocating, law for the public good. The other, sometimes called the thin conception of the rule of law, better described as rule by law, is the idea of legalism, the use of law as a vehicle through which men rule. And that can be useful too, but it could also be very dangerous. And this is what I think we were criticizing, for example, in Africa. On the one hand, the rule of law, on the other hand, rule by law or the rule of men. I think that Professor deGuzman does us a great service when she says that law and love are closely linked. Love, and I'm now going to just modify a bit in the sense of caritas, to care for others. In other words, to care for the common good, to care for our collective welfare. And the common good conception of justice has always been the central value of the rule of law. So throughout history, there's been a very, very close and often referred to link between the common good and this conception of the rule of law. And I think that's essential. I think it's essential that we think of it in that way. The purpose of this enterprise is to create a regime in which all persons can live worthwhile and fulfilling lives. And the problem with the rule of law, in fact, the problem of the absence of the rule of law is the ability to not take people into account, to oppress people and not regard their dignity as having value. I think the enterprise of our international law system is supposed to be and should be service to the common good in the way that Professor deGuzman urges us to do. Professor deGuzman, you're the next little thing. And then we're going to go to questions that may have accumulated from our audience. And Professor deGuzman.
Sure. I mean, since I went last, I had the benefit of your comments before I gave my initial ones. I don't think that we are disagreeing much yet about anything. I think my emphasis perhaps is on understanding, if I put it in the terms that both of you are using of the arbitrary use of law, that it's important when we think about what is arbitrary to think about the values that ought to infuse the application of law, both the application and the creation of laws. And so I appreciated the framework that Greg put forth at the beginning. And I also think that we need to take account of the role that emotions and in particular these, as Greg pointed out, the negative, but also the positive that we want to have motivating the application of the rule of law in thinking about these issues. So yeah, I'm curious to see what the audience thinks. So let's go to that.
So I would now invite Dr. Dowdy Wagner to select questions for us. And while she's doing that, I just want to mention that I noticed amongst the questions a statement by Dr. Hans Corell, who I thank for being here, that he has prepared in cooperation with international organizations a pamphlet only 40 pages long that's available on the internet, in which he speaks about practical aspects of the rule of law that could be available to politicians who are trying to improve the rule of law within their own jurisdiction. I just noticed that in the chat, and I thought I would draw that to your attention. Dr. Dowdy Wagner.
Thank you, Tim. We have some excellent questions. So I will start with the question from Alfredo Rizzo, who said, what is for you the proper way to assess how the rule of law and human rights law interact? Is it fair to say that rule of law standards might also be misapplied and legitimize unfair behaviors, both national governments and big private companies, unless human rights come into the picture to mitigate such powers? This means that rule of law and human rights law should be improved together in the international arena, but they may both be challenged to a certain extent, e.g. international investment law, as far as powers of big companies.
Would either of you like to react? Professor Schaefer, are you preparing to react? You're silent.
No, I'm sorry. I was going to let you react first, Tim, but I mean, it's a great question. In my own view, I think that they are complementary. The question is, there's obviously a huge discussion over which human rights. You were talking about civil and political rights, social and economic rights. There's so many different rights. I think that the rights exist in order to create checks on the arbitrary exercise of power. But since there's these, I hesitate in saying that the rule of law itself has to have once you start moving in terms of, I view human rights, in other words, as means to try to check the arbitrary exercise of power. But the rule of law has this goal, this predominant goal on this check, and then it's open to different means. I think when you start talking about rights, it's also quite interesting in terms of ultimately, how do rights play out in practice? Which contract rights, property rights, or political participation rights. There's some overlap. Clearly, once we start talking about, for example, due process rights, the right to a trial, the right to not to be, not to be tortured, because they're all linked to the primary goal of rule of law, so that we can live our lives without fear of, and that's sort of like the central core concept of it. So I think they work in parallel, but I think that given the expansiveness of different types of rights, I would look at them as parallel means to try to address, to check the arbitrary exercise of power.
I think in the interest of getting many questions, we'll have one of us answer each question, and then you can, if you have something that goes with another question, you can slip it in answering the other question. So I'd like to invite a second question, although there was a lot that could be said about that last question.
We have some long questions. So I will go to a short one to break things up. So from Tyler Dixon, we have, with global power dynamics shifting, what challenges and/or opportunities does a multipolar world pose to international rule of law? An easy question.
That is indeed extremely broad, but I will take a stab at saying something there. I think that there are some real opportunities, and again, I'm trying very hard to stay in an optimistic frame, and sometimes that I think are very challenging. That the increasing multipolarity, I think, gives an opportunity for more visions of the good and the common good to be maybe I'll say become more powerful than was possible or has been possible under a regime that was very much dominated by one power, or by a very small number of powers. So if power continues to become more diffuse, which may be happening in particular with technology, I think there are some real opportunities for creativity and radical thinking about how to reshape the world. I'm not predicting necessarily that this is where things are going. However, I do think that there are opportunities there for new conceptions of the rule of law and its application. And I'll just slip in here a sort of coda to what Greg was saying about human rights and the different kinds. As an example, in answering this question, I would say we've had a very strong focus on individual rights, civil and political rights, for many years. And perhaps the shifts in political dynamics that are happening may give some opening for a recalibration and more emphasis on some of the other rights that focus more on the communal and collective rights and rights beyond the civil and political.
Thank you. Thank you very much for that. And I think we should just go to another question.
Okay. We have a question from Jose Hol Pena Yanis, professor at the National Autonomous University of Mexico and the Secretary General of ILA Mexico. He says, we are witnessing international law being sharply questioned for its ineffectiveness, illustrated, for example, by the UN's frequent paralysis on the gravest crises due to a Security Council hamstrung by great power vetoes. At the same time, some states cloak manifest violations in selective invocations of legal principles and even binding instruments. Are we then facing a, quote, made-to-measure international law tailored to power rather than rules? If so, what concrete institutional or doctrinal reforms would you prioritize to restore effectiveness and good faith compliance?
Well, I'll try that one since I think I'm next. And the short answer is, I think that this argument that we're making for the rule of law has a strong normative component. if you argue as we have argued that the essence of the rule of law is its of the violation of the rule of law is its arbitrariness, that has a normative component. Arbitrary means arbitrary in terms of the purpose of the enterprise. So in order to say something is arbitrary, you have to have some kind of conception of the purpose of the enterprise. And I think that our enterprise, international law, I think its purposes are quite well known and well spelled out in many places, including in the United Nations instruments. But arbitrary certainly, and this gets to the first question from Professor Rizzo, in this case, human dignity and human rights are one of the central purposes of this enterprise. If we are going to take everyone into account and respect everybody, we have to be able to identify those things that should not be done to any person. So I think respect for human dignity and human rights is very fundamental to the purpose of our enterprise. And if it is, that gives us a stick against which to measure some of these false claims to be advancing the rule of law. So if I understood the last question well, it was that our international institutions are too weak or in some cases badly intentioned to do anything useful, and that very often powerful states claim to be enforcing or advancing the rule of law when in truth they're advancing their own power. And I think all of those things are contrary to the rule of law and can be criticized in terms of the rule of law if we have a standard for the rule of law, which I think we do have. So the International Law Association, I think our real power is our ability, if we can do it, to present a united consensus front about the fundamental principles of international law. And if we are able to agree among ourselves on these fundamental principles, I think that will have a power to some extent to control some of these lawless states. That's why I'm so critical of this concept of essentially contested ideas. If they're essentially contested, then we can't use them to protect ourselves and others. So I think it's important that we try in good faith to understand well what are the fundamental principles of international law. And I think that is how we answer these states that are not acting in good faith.
I have a next question from Rebecca Shute, who says, where tools conceived to promote the rule of law, such as sanctions policies, are instead deployed against legal professionals, civil society advocates, and human rights defenders, how can we as a community come together in our resistance and solidarity?
Yeah, I said in the chat that I wanted to answer this one, Rebecca, because I wanted to give a shout out essentially in my answer to you and to those who are doing the incredible work that you're doing. I mean, I think exactly what you're doing is what we have to be doing. In other words, Rebecca is, for those who aren't seeing the questions, the co-convener of the Washington Working Group on the International Criminal Court and Impact Coalition on Strengthening International Judicial Institutions. And I think you're devoting your life to exactly what we need to be doing, which is to stay organizing at the grassroots level, at the civil society level, to combat these abuses of law. And I think there are some real, again, I'm so committed at the moment to positivity. There are some real important technological changes happening that are increasing the ability of civil society to organize. I mean, even the fact that we have, now you organize regular calls with these groups that, draw people from all around the world is a very significant change in just the recent past of the ability of civil society to organize to combat these. So it's not easy, and the forces are pretty intensely aligned in negative directions in some contexts at the moment. But I just really appreciate the work that you all are doing, and I wanted to give a shout out there.
So we're coming close to the end of our time, and I want to choose one last question, which I will address to Professor Schaefer, who I know has to leave the conversation fairly soon. And Professor Schaefer, in addition to answering this question, if you could just turn it into any concluding remarks that you want to make as well. But this is from Professor Miroslava Antonovich, who was the rapporteur of this group, so I think her interest is particularly important. And she's from Ukraine and is talking about how for almost 12 years in Ukraine, many of the fundamental principles in the UN Charter have been violated and continuously violated by powerful states. So does that, how does that, it's a bit similar to one of the questions we already tried to answer, but do we have to, are there principles that need to be reformulated in the light of this reality? It's quite discouraging to see such horrible things happening. How do we make fundamental principles work? Is there something we should be doing or could be doing to make this more effective? Professor Schaefer. And I know that you, Professor Schaefer, were in Ukraine yourself talking about the rule of law, so I think it's closely related to your own interests as well.
Yeah. So, and Meg was there, and Tim. Yeah, we were all there. So, and we made a documentary, which won the best short documentary prize at the Berlin Festival on that trip, which was support Ukraine and the rule of law. I mean, there's no doubt, we see erosion in the rule of law simultaneously at the national and international levels. This is pointed out, unfortunately, by Viktor Frankl's work in earlier times. I guess what I just want to maybe conclude by a few sort of thoughts in terms of, one, it's up to us. We need to continue to engage. We need to engage at multiple levels. We need to engage both at the domestic level and the international level, because the two are interlinked. If you think about, in terms of the principles, that I think just from a basic minimalist principle, international law, so much of it is focused on international peace. And there's no sort of more risk of the arbitrary exercise of power than with war and violence, as we see in Ukraine. So it leads to torture. It leads to arbitrary killing. It leads to civilian deaths. And if you think about the core norm as the violation of the use of force except in self-defense, whereas authorized by the Security Council, it's the central norms, the international order that Russia's violated, it's core to them. The other, if you also think about the role of international courts, then there's really reasons to be pessimistic given current trends. We're in a vicious cycle right now of declines in the rule of law, both domestically and internationally. But really want to point out sort of the importance of international courts. Even if we see, horrible violations, such as with respect to Ukraine or what's happening in Gaza, if you think about boundary disputes and international courts, not just the International Court of Justice, but also the Permanent Court of Arbitration and so forth. And in the introduction to the book, we did some empirical work and saw that there were 53 boundary disputes that were decided under the internet since World War II. And states brought these cases and litigated these boundary cases before the International Court of Justice or other international tribunals. And they actually complied with the decision 85% of the time. Think counterfactually, if we didn't have international courts, if we didn't have international institutions, it'd be much more difficult for states to resolve boundary disputes, and it's boundary disputes which lead to war, which lead to conflict. And of course, that's under risk today. I just want to also point out that this goes back to human rights, but just that international human rights provide normative resources, not only at the international level, but at the national level. If you think about, an earlier time with the Helsinki Accord and the impact of an accord which was not binding, which is not, thus quote, not hard binding law, but it nonetheless had provided normative resources to people in Central and Eastern Europe. And we see this, I hope now today in Ukraine, to stand up for principles and to challenge sort of this sort of exercise, what we see with the Putin regime, what it's doing. Of course, not only in Ukraine, but also it's become much more autocratic in Russia itself. And then third, of course, international law provides direct legal protections and legal accountability for individuals, especially in the human rights courts. And these institutions we need to defend. We see one of the first things that the Putin regime did was, after the war in Ukraine, was to withdraw from the European Court of Human Rights. And before that, to try to create barriers to the enforcement of the European Court of Human Rights rulings within Russia. These institutions, the reason why they do that is because they do. If they didn't matter, they wouldn't withdraw. They wouldn't create, new blockages for these rulings. These institutions are important again for providing normative resources to the most vulnerable among us. And so I just want to conclude by just saying that, these are very difficult times. There's always power always wishes not to be constrained. And so it's going to be an ongoing struggle through time. But rule of law principles, rule of law norms, and institutions that uphold them are central. They're central at the national level, but they're also central at the international level. And so sort of this wave, and there's been all sorts of problems with economic globalization in the United States and elsewhere. But that creates a temptation for us to turn inward. And I just maybe would say my final words with this quoting, the philosopher Kwame Anthony Appiah, originally from a family from Ghana. And he wrote, as populist demagogues around the world exploit the churn of economic discontent, the danger is that the politics of engagement could give way to the politics of withdrawal, forgetting that we are all citizens of the world. A small, warming, intensely vulnerable world would be a reckless relaxation of vigilance. He concludes that elsewhere has never been more important. So maybe I just, in terms of us who are engaged at the international level, it's just so central, not only in terms of cooperation and relations between states, but also for all of us, wherever our home may be. So thanks, Tim. Thanks, Meg. Thanks, everybody, for inviting me to be part of this.
Thank you very much, Greg, for those excellent contributions. I think you really left us on a beautiful note with that reference to Professor Appiah.
I have to go, unfortunately, for an event here.
Professor deGuzman, any last reactions?
I actually think that Greg's last quote was an excellent place to leave it. And for me, it also brought in the importance of, again, centering, I think Professor Appiah's quote is very much centered on this idea that I'm trying to focus on of loving one another, loving all of humanity, caring for all of humanity. And even in the way that we think about and apply law, keeping those emotions, those values central. And so I think that's an excellent place to wrap up. Not going to add to that. Thanks so much, everybody, and thanks for including me.
Thank you very much, Professor deGuzman. Thank you also to all the people who are participated in this by coming into the webinar, including those who sent questions. There were a whole lot of questions, and we have not answered all of them. But I wanted to stress for those of you who did have questions that were in the chat that they will not be forgotten because we're saving them. The International Law Association has created a study group on the rule of law and international relations. And so your questions will be the first thing that are addressed by this study group. One question in particular that I myself might have wished to answer focused on the fact that there may be differences between the rule of law within states and the rule of law between states. In other words, international law is not exactly the same as domestic law, and that may affect how we understand the rule of law. And I think that's a wonderful observation that we're going to have to think a lot about and for which we do not yet have, or I do not yet have, an answer. But I just wanted to give that as an illustration of the very interesting questions that we were asked that we hope to answer. I want to thank the American branch of the International Law Association for sponsoring and encouraging this, particularly the interest group on the legitimacy of international law. And I want to say to all of you who are able to get there that International Law Weekend is the weekend after next in New York City. And I hope I'll see some of you there. If you are there, I will be there. Come up and introduce yourselves. Thank you very much for being part of this event. Good afternoon.